So happy Friday, everyone. My name is Christina Jimenez.
And I'm Josh Floyd.
And we are attorneys over at the Jimenez Law Firm. We have been practicing for, goodness, about 24 combined years at this point.
God, you're old.
We're so old. And so every Friday at noon, we come together. Sometimes it's just us. Sometimes we have members of our team. We have other lawyers that have come on, ex-clients. And we just talk through complex fact patterns. Sometimes complex, sometimes not so much complex, but we just talk through them. And our hope is by spreading some information that perhaps we can give others some insight into the legal process and maybe give you guys a little bit of hope in finding some light at the end of the tunnel. And maybe you can use this information to help your attorney or to ask your attorney some questions to see if maybe it's something that could eventually help you. So we always ask that you all please follow us on social media. So TikTok, Instagram, Facebook, LinkedIn, I don't know, any platform you can think of, follow us on it, please. And with that being said, Floyd, the legal advice staff, you want to give that disclaimer?
Sure. Yeah. So nothing we say here should be taken as legal advice, although we are very, very knowledgeable and what we're telling you is probably correct, especially when I'm talking. Don't take it as legal advice. You'll see as we go through this that our opinion will change through all the various fact patterns Christina takes us through. When she goes down all these roads, you'll see. So don't take it as legal advice. This is just kind of an information session for you to give something for you to talk about with your attorney or when you're looking for an attorney or whatever. So not legal advice.
Excellente. All right. So shall I read the first question?
You should, but I think it's been like a month since we've been on here together.
I know. You don't ever work anymore. So
it's been great. I think the people know who's been on.
Right. Okay. So first question, does a judge have to make a ruling in a contempt case regarding child support? So my ex was brought into court and contempt of transport. I was told I did not have to appear. What? I think in contempt of child support, maybe? Okay, I'm going to go with my ex.
There's no way that says child support.
What?
There's no way that says child support.
I don't know. Okay, so my ex was brought into court for contempt. I was told I did not have to appear. I did not attend the second court date. I don't see a ruling, and the only thing that I've gotten is a piece of paper for a review hearing in January. Does this mean there is no ruling or that I just have not received it?
So I think it depends. I'm going to go with this is probably an AG case.
Yeah, I concur.
I think it depends. I mean, I don't know what happened on the second court date. Any number of things could have happened. Since it's the attorney general that brought the case, they could drop the contempt, they could put him on probation or whatever. There should be an order if there was a ruling. Yeah, so I don't know what it means. It could mean anything. It could mean the case is dismissed. It could mean anything. I think that you probably should have attended. I understand relying on the attorney general, but in order to know what was going on, being there would be your best bet.
So let us talk through.
Yes, of course.
What the Office of the Attorney General is and what it is that they do. Mr. Floyd.
Okay, so the Office of the Attorney General is a state-sanctioned body. Basically, they're attorneys for the state. They make sure that we are not costing the state money, right? So if the child's on Medicaid, they're getting involved, so the state's being reimbursed, and they make sure the child support gets paid. They don't really care about possession and access or conservatorship or anything like that. their primary function is to make sure child support and medical support is being paid. So that's what they do.
So a lot of times when they get involved on their own, it's because a parent has applied for Medicaid or CHIPS or some other sort of government assistance. And so if you're applying for those benefits, then what will oftentimes happen is they'll say, well, if you have children, is the father paying support or is the mother paying support, right? And if they are not, then that will typically be what prompts the AG case, right? But you can also go in and, fill out an application and ask for their services and ask that they file a case so that you can start collecting support. They will also set up conservatorship and possession and access and all that other good stuff for you guys. And so they're definitely helpful, right? And I think that in a lot of cases, sometimes it's the only choice that a person has. And sometimes they don't need to spend thousands of dollars on an attorney, right? I mean, they can just have the AG handle it for them. And so the biggest thing or misconception that I see with the AG is that people have this perception that the AG is representing them as an individual. So if mom hypothetically has the kiddos, mom thinks, well, the AG is going to take care of me and they're going to have my back. And that's not necessarily the case, right? The AG is interested in protecting the state. So they want the child support to be paid. They want for the health insurance to be paid as well. And that's going to be their primary concern. And so if someone is not paying child support, they also have the ability to file a motion for enforcement to put them in jail to make them start paying, right? Floyd, what is your opinion on parties not having attorneys whenever they're dealing with the AG?
I think that sometimes it's necessary because they can't afford attorneys, but if there's any way to get an attorney, you should do that. When they're dealing with, conservatorship, which is the rights of parents, and possession and access, like I say, the attorney general, they don't care, right? That's not their thing. And so they've got these little forms, like checkbox forms that they use. And generally it ends up poorly written for the non-custodial parent.
Right. Well, and oftentimes too, I've seen it where even for the custodial parent, like they imposed a geographic restriction, but the mom or dad didn't even know what a geographic restriction was, right? And so now they're stuck to a certain area and they don't know why or how and what to do to get out of it, right? And so the other thing is, like in this particular case, and I've had it happen to me on a couple of different occasions when I first started practicing, there would be an enforcement filed by the Office of the Attorney General, and then we would show up relying on that enforcement motion. And then for whatever reason, the AG would say, well, we're going to drop it, right? Like maybe dad paid a lump sum amount, or maybe, there was a medical issue for the other parent. And so the AG felt bad about putting him in jail. And so they drop it. And then at that particular point, you are put in a position of having to reset the hearing, potentially filing your own motion for enforcement. And it just creates problems, right? So I always recommend anytime you're dealing with the AG, if you can afford one, absolutely 100% get it. And so get one. And in this particular case, what I think probably happened is they went to that court hearing and maybe the judge was going to give dad some time to maybe come with some money. And then they did a reset for a review hearing so they could determine if they were going to actually put him in jail or not. Because the AGs, for the most part, their thinking is, we don't want to put people in jail. We want people to pay. Right. And so if they can avoid putting people in jail, and if somebody promises that they're going to come up with a big chunk of change, they may say, okay, that's fine, do that. Because that's their end goal, is to get money, right?
It's very true.
Yeah.
Although in that case, so they kind of did the review hearing, but it was an AG case. They held him in contempt, sentenced him to 10 years in jail, or 10 years. Holy cow, that's a long time.
I was like, that ran concurrently.
They did not do that. They sentenced him to
I mean
180.
consecutively.
Yes,
Sorry. Okay.
they
Okay.
sentenced him to 180 days in jail to start 90 days out. And then they appeared at that 90-day hearing where he was turned himself in, and then they suspended his sentence at that point.
Interesting. I don't know that I've ever had that happen before.
Yeah.
So the other thing is most AG courts, so anytime you go into most courtrooms, right? So I think the associate courts in Dallas County, they don't have court reporters. But most other courts that I've ever been in, they have a court reporter that as we are speaking, you have somebody there that is typing everything that we're saying, right? And so most of the time when you go to an AG hearing, they have a like a little digital recorder, and the judge just keeps that digital recorder there. And then if ever you need to request a copy of what happened at that hearing, you what do they do? Do they give it to a court reporter and then the court reporter transcribes it and sends it to us? I feel like we haven't done that in a long time.
I think you just get a copy of the recording.
Is that what we get? Yeah, I haven't, it's been years since we've had to request something like that. And so you get a copy of the recording so you can figure out what actually happened at that court hearing. And so there is a record. It's just, not going to be by a court reporter. And then the other thing is you can check the docket entry, because sometimes they'll put a docket entry on the online portal so you can kind of see what happened there. And you could also try to call the Office of the Attorney General to try to figure out what happened. They should have some sort of a record as to what took place. And yeah, next time hire an attorney so you don't have that issue. See?
Next question.
Next.
How do I get a copy of my child support order? This is an easy one. Child support continues to get deducted from my salary, but my children are adults, 25, 22, and 19. I need a copy so I can stop the deduction.
So the simplest way to get a copy of any court order is to go to the district clerk's office in the county where that order was rendered, right? And so you basically go there, there's a little form that you fill out, you say, this is what I need, and then they'll charge you typically, like $1 a page, something like that.
Yeah.
And then you pay your fee, you get a copy of your order, okay? But what I think that you probably need is not a copy of your order. I think that you probably need a financial activity report from the Office of the Attorney General. Because if they're still garnishing the child support, there's a chance that perhaps you are in arrears and you're still paying on that back child support. Okay. So I would encourage you to contact the Office of the Attorney General, get that report. And then at the end, it'll show, yes, you have a balance, or no, you do not. Obviously, if you don't, you need to file what we call an income withholding order to terminate the child support obligation so that they'll stop garnishing it from your paycheck. Okay. And typically, that's not something difficult to get signed by a judge. If in fact you have your court order showing that your obligation is terminated, then you should be able to get an IWO. And then you're going to have to file what we call a request for issuance. And so that is a form that you fill out again at the district clerk's office. And you pay like a $15 fee, something like that. And that's the form that will help the district clerk to process that paperwork to get it to your employer so they actually stop paying child support or taking child support from your check.
So assuming he's not in arrears, right? And it's just an oversight by the state, can he get this money back?
Why, of course he can. Yes. Great question, Mr. Floyd. Would you like me to answer?
Absolutely.
Okay, excellent. So there is a thing that you can file, and it is called a petition to recover overpayments of child support. Yeah, that's what it's called, right? Yeah, I think that's what it's called.
If not, that's what we'll call it.
That's what we're going to call it today. And so basically, it's just a petition where you state, hey, I have my child support obligation terminated here. I overpaid on this date, this date, this date. Here's the amount that I've overpaid. And so now the custodial parent owes me money and needs to pay me back. I guess we've had some judges that make them pay it back in a lump sum. most often they do payments like they would for child support, right? And it's a court order and they have to pay it. I would presume that we could hold someone in contempt for that. But I don't know that we've ever had a case where we attempted to do that. And so we'd have to research that issue.
I feel like it would just be a debt.
You think it would just be like a judgment type thing? And I don't know, but I don't know that I would want to find out. So just pay it. If you get a judgment, just pay it. So, or go and talk to another attorney and make sure they do the research and they'll tell you what to do. But you do have the ability to collect that money. And so for sure, you should try to get that back if it's substantial. Cool tools.
Your purse.
Okay. Next question. How can my child support amount get raised? I only received $200 a month for child support. The father was waiting for a transplant and has received his liver. Now that everything is fine, the father now owes the kids and uniforms for school. Can I reopen the case?
Absolutely. So by everything is fine, I assume you mean he now has a job, right? He's back able to work and is working. So what you would do is you'd file a child support modification. You do have to show that the amount of support would increase by $100 or 20%, right? 20%?
Both. Or I always get it screwed. It's like 100. Excuse me?
I think it's an or.
Yeah, I think you're right, Mr. Floyd. Good job.
What are you asking me? I'm so confused. You said both.
Well, I know, but I meant or. And I said, I think it's or. And then all of a sudden you said, I think it's or. So I know that it is or, but continue.
Okay, well, I think that it's an or. Not both, as Ms. Jimenez had represented previously. Either 20% or $100. Or you can show that there's been a material and substantial change. In my opinion, the fact that he has received a transplant and is now working, making substantially more would be a material substantial change, which would allow you to go back even before the 3 years, right? So you file a modification. I don't know what you mean by owes the kids and owes uniforms. I guess maybe he hasn't been paying child support.
Maybe.
So you could deal with that then, either file an enforcement or confirm the arrears.
But how likely is it that judge is going to put him in jail for not paying support if he was undergoing a liver transplant?
How long has he been fined?
I don't know. Let's just say he's only been fined for 2 months.
Then not very likely, but let's say he's been fined for 2 years.
Then very likely. But I create the fact patterns here.
Oh, sorry. Okay.
Right. Okay. So he's had a liver transplant. If it's been recent, who cares? He's not going to be held in contempt. What else?
This is assuming that he's working, right? I don't know if he has a permanent disability as a result of the liver transplant, right? If he does, then you could base child support on his disability income. $200 a month, that's even below minimum wage.
He must have other kids. He has to have other kids as well, because that doesn't make any sense. Yeah. So
he's capable of working but not working, right? Then you could ask that child support, you could claim intentional underemployment or unemployment and ask that child support be based on his earning ability rather than his actual earnings.
That's so that's a good argument. That's where I was going to go with it. But that's so freaking difficult to prove a lot of the times. And especially when you have a health issue like this, right? And so then you kind of have to get into getting medical experts and maybe getting some PIs to show, like, look, judge, he's claiming he can't work, but he's out front mowing his lawn. He clearly can do something. He's just choosing not to. You're going to want to look at his medical records to see if they say that he's able to work or not. There's all sorts of craziness that you can get into in all of that.
bank statements and expenses to see if he's working under the table for cash or something.
Yeah, yeah. But it's definitely worth looking into because $200 a month, dude, like that don't even buy a pair of shoes these days. 2 pairs of shoes, if you're lucky.
Yeah.
Shoes are expensive. Your kids don't wear $100 shoes. I'm sorry. What did you tell me about Lululemon yesterday? Yeah, exactly.
Yeah, no, my oldest does wear expensive shoes. My little
Like you take the others to the Payless, huh?
They go to Payless.
All right. Once my child support is paid and I have my case file.
Do I get to ask a question?
No, you need to answer this one.
Okay.
I would like to have a complete case file once I pay my support in full. Can I have a copy of it? A criminal case file is they're allowed to have one. So why can't I have mine as well?
I think he means from his attorney.
From the AG, probably, because that wouldn't make sense if it was from his attorney.
Yeah, I guess they're not going to have anything except for the order. So, yes.
Next question.
Yeah, I don't understand.
No, so I think what he's saying is like his entire case file. So let's just say that it's with the AG, right? So what you need to do is the AG is probably not going to give you anything other than a financial activity report, right? Yeah, that's probably it. The rest of the documents, you have to go to the clerk's office and you have to pay for them. And then you can get a complete copy of whatever was filed in your case there. If you're talking about a private attorney, that file is yours. And so if you ask for it, we have to turn it over to you. So you should be able to get it that way. Easy breezy, lemon squeezy.
Yeah. So my ex wants me to pay full rent after abandoning me. I have paid half my rent and he is legally on the lease. He expects me to pay in full after leaving without moving out and has not communicated about the move or transfer of the lease to me.
He expects me to, so he left the house and the lease is in both of their names.
And he said, I ain't paying nothing.
I mean, frankly, if she's only paying half, I don't think that she's going to be able to stay there. So, I mean, how badly do you want to stay? If you want to stay, then you got to pay. Oh, there's nothing else that we can do. Yeah, I mean, the apartment complex or whatever it is, they're going to want full payment. They don't care that you two broke up and he abandoned you and all that good stuff. They want their money. And if you don't pay it, then they're going to come after you and it's going to affect your credit. It's going to affect your ability to get another place in the future. And frankly, if he is indifferent about his credit, then, yeah, you're only hurting yourself and you're going to end up having to move out anyway. So, I don't think that's a good move. Now, maybe you're playing this game of chicken with him to see that, if he'll pay because you don't pay. I mean, I guess you could do that. But at the end of the day, you're the one that's living there. So how badly do you want to stay there? Is the question.
Yeah. And I don't know that they're married, but if they were married, right, then you could go to temporary hearing and maybe get some spousal support, get a court to order him to pay half of the rent.
Mm-hmm. So should we talk about spousal support or no? This isn't the question. This is the lease question. I mean, you're the one that brought it up.
Let's go there.
Let's go there. Okay. So spousal support, temporary spousal support. Floyd, how long do you have to get married or be married to get temporary spousal support?
Depends. Has there been family violence?
Temporary spousal support. Oh,
I didn't hear the word temporary. 1 day.
Like 1 hour?
1 hour?
1 minute.
That would be quick separation. You're walking back down the aisle.
Right. Exactly.
Like, screw this.
This is too much. So there's no amount of time that you have to be married in order to get temporary spousal support. Everybody is eligible for it. Obviously, if it's a minute or an hour, it's less likely that you're going to receive temporary spousal support. But it really is need-based, right? And so what the court is going to look at is they're going to look at how much money do you earn as the person that's requesting the spousal support? How much do you earn and how much are all of your bills? Okay. So let's just say, hypothetically speaking, that you make $5,000 a month and you spend $6,000 a month. And that's what you need for your minimum reasonable needs. Boyd, what's that? Minimum reasonable needs.
That depends.
Tell me. Do tell, sir.
So, we debate this topic, but I believe minimum reasonable needs is enough money to provide for you a place to live and food on your table and clothes on your back. It doesn't mean a mansion. It doesn't mean these lemon shorts or $200 shoes or whatever it is. And it doesn't mean eating caviar, right? Just to make sure that you have shelter, clothing, and food.
So I think that it depends on the judge, and it depends on I guess, lifestyle that you are accustomed to. I don't think the caviar, we're probably not going to get the caviar, but I think that if you have been driving a vehicle and your vehicle cost $1,000 a month, and that's what you've driven for the past 3 years, I think the judge is going to say that is reasonable under this particular circumstance, right? If you've lived in a home and your home is, your mortgage payment every single month is $4,000, and that's what you need to be able to live on a temporary basis, we've had some success in that, right?
Well, so let me caveat this. On temporary, I think there's a little more giving than on final.
So I'm going to need you to pay attention because we're talking about temporary.
I know,
literally,
but you just specifically asked for a definition of minimum reasonable needs.
Okay, that's okay. So now you're trying to back out of your answer?
No. I stand by my answer for final. I think what happens in your $1,000 a month payment is judge says, I'm going to give it to you now, but get rid of that damn car before final.
Sometimes it depends on the judge, right? But it depends on the vehicle, right? You're upside down, and if you're going to lose money by trading in the vehicle, and it also, so I guess let me go back to what I was saying. So 2 things that the courts typically consider. They consider how much money do you make and how much are your reasonable minimum expenses. Okay. And that is a fact scenario that Floyd and I could probably argue about all day, but I definitely think it's a case-by-case basis, right? If you're running out and you know that your husband's about to leave you, and so you decide you're going to get you a vehicle at $1,200 a month and you've never had one, you're probably going to get stuck with it, right? But I think that what the courts look at is the history of the parties, and then they make that determination, right? So the other thing that they're going to look at is they're going to look at your spouse's income and their ability to pay, right? And so if your spouse earns $20,000 a month and his expenses are only going to cost $10,000, well, now he's set up with the ability or potentially has the disposable income to help you with your temporary spousal support, right? But again, it's only on a temporary basis. Some judges cap it. So some judges will say you're only going to get this for 3 months. And so you better start cutting expenses. You better get yourself a better job because you're not going to get it forever. Others, like you said, Floyd, will say, I'm going to reimburse him at a final hearing, right? And he's going to get that money back. So, which I'll say we've tried that, or I've tried that, and I haven't had a lot of success. And the judges were kind of, because obviously typically when this happens, I'm representing the husband, and the husband's been the primary income earner, and the wife was maybe, stay-at-home wife, or maybe she was sick or something like that. And so at the end, when we try to go and argue for that, the judges are like, no, not doing it.
Yeah,
Have you
I
had
have
any
much
success?
I
Yeah,
have not had much success with that. But I think there is another factor that they look at when determining temporary spousal, and that's fault, right? If the guy just takes off and leaves the woman, or vice versa, right? Just leaves them, takes money out of the account, kind of their behavior after separation. I think the judges take that into account because they're not going to reward that type of behavior.
right, right. And so I feel like we've researched this before, talked about it, and that's the question, is there a cap at temporary? What did we decide? That
I don't think so.
I don't know that there is either. I don't think that there is. So at final, you're capped at 5,000 or 20% of your gross income or net income. I can't remember.
I think it's net, but doesn't the amount depend on
The length of the marriage.
does it, or just, so I know how long you can get it for, does, but does the amount depend on that?
I don't think so. Man, if only there was like a book that we had
Yeah, that'd be
that was
crazy.
real, like within arm's reach of us, and we could like pull it out and look at it.
That would be helpful for sure. That would be. What do you know?
Look at that,
Crazy.
boy.
Let's see what we got here.
So for some reason, I feel like it's the 5,000 or the 20%. And I think that the only differentiating factor is the length of time. Based on the length of marriage, you can get it for longer. But I don't know.
We'll find out here in just a second, maybe.
So while you're doing that, just a kind of a quick note about our team, our firm. So every single attorney and paralegal, his little set of books that he has there, we all have them, because even though I've been doing this pretty much all day, every day for 14 years, I still can't remember everything. And so I'm constantly pulling out my code books, my handbooks, I'm highlighting, underlying, reading cases, trying to remember this stuff. And I think most lawyers are probably like that. I've met, I think, one that was able to recite statutes by memory and case law and all that stuff. But
Yeah, and we met what, 10 years ago or something, right?
oh my God, it was not you, Mr. Floyd.
Oh, okay. So did you say that just so that people know I'm not special? Like he's not the only one with those books.
No, I was trying to fill the time so there wasn't just a bunch of dead air time, but yeah, exactly.
Well, it didn't work for you.
You still haven't found it, Floyd?
No.
Oh my gosh. Okay, where's Julie and James and Greta and Karina?
Yes, I found it.
Okay, what'd you find?
It's 5,000 or 20%.
Okay, perfect. So 5,000 or 20% of gross or net?
Gross.
Okay, and so even if your expenses at a final hearing are, if you're short every single month, like 7 grand, 8 grand, or whatever, it's the lesser of, right? So you're going to be capped at the 5,000. And so I can't tell you the number of times that I have had a consultation with, typically they're women, and they kind of tell me like, listen, this is the lifestyle that I'm accustomed to. And I have to tell them I understand, but that is not going to continue if you get this divorce, because they're used to spending, 20, 30 grand a month on stuff. And once you get a divorce, sometimes, I mean, you're not going to get it from him, right? If you can obviously do it yourself, then you do you. But if you can't, then you're going to have a potentially a tough time financially once this thing's done. So the length of marriage, what is it? 10 years is 5, 15 years is 7, and then 20 plus is 10 years.
Married for 5 years, you can get 10 years of support.
Married for 5 years, you can get 10 years of support. You have that backwards, but
Yeah, sounded good. Married for 10 years, you get 5 years of support. Married for 10 to 20 years, you can get 7 years of support. I wish I could read.
I was gonna say, I wish you knew what you were talking about right now.
Yeah.
That would be very helpful.
I gotta quit drinking before Facebook Live. Hold on.
You know what? Disregard. Just disregard. The point is, no matter, depending on how long you're married, it will determine the length of support that you're eligible to receive. You're not going to give it up, are you?
Not.
So while you're looking that up,
So that was my confusion. Yeah. So 10 to 20 years or less than 10 years plus family violence is 5 years.
okay.
It's 7 years if it's 20 to 30 years, or 10 years if more than 30 years.
Oh, so you have to be married 30 years to get 10 years of spousal. Yikes.
Yeah, it's not worth it.
And the family violence, that's a conviction, right? Or deferred?
Holy hell. I don't know.
I want to know. I haven't looked at this in a while.
Convicted or deferred.
Okay. And so if the spouse is either convicted or, and that's something that I think a lot of attorneys miss, like we all just presume, okay, family violence happened, but they've only been married for, 3 or 4 years. And then we kind of just keep going and we miss the spousal support element of it, right? But that is important that we keep that in mind if they're convicted or receive deferred. So what's the longest that you've received spousal for?
I don't know. I don't know that I've ever received it for 5 years.
So I've received it on one case for 10, but the facts in that case were terrible. Great for us, but terrible for the other side. But every other case, I'm right there with you. It's like, 4, 5, 3. And so here's the other thing that judges look at, and this is the kind of the difficult part of selling or making a spousal support claim, is the other thing that they have the ability to consider is the division of the estate at the time of divorce, right? And so typically if you find yourself in the situation where you're spending, $15,000, $20,000, $30,000 a month, most often than not, you're going to have assets, you're going to have, retirement accounts, investment accounts, you're going to have equity in your home, et cetera, right? And so if you have all of those things at the time of divorce, the judge is going to say, listen, maybe you're short each month $4,000. Okay. You're going to be short for, $4,000 each month, but you have $500,000 in cash sitting in an investment account. You're going to be fine, right? You're going to be okay. So you don't get spousal support, right? I would say, and it doesn't matter. It doesn't matter if your husband is making $50,000 a month. You are not going to receive spousal support if you have a big chunk of change sitting in an account.
Yeah, because to determine whether or not you have sufficient means to provide for minimum necessities, they not only look at your income, but also assets, right? Separate property, community property, all of that.
And they do have to look at the liquidation of those assets, right? And like the taxes associated with all of that and, any penalties that you may lose. And so if the only thing that you're walking away with, and I've had that happen in a case where my lady was walking away with a house, and I want to say she had like $500,000 in equity in the home, but the husband was getting the retirement accounts and the investment accounts to offset the estate. And it was very, very important to these children that they stay like in this home. In that particular case, we did have success in getting spousal because the court was like, listen, she has a house and that's lovely, but she's not going to be able to sell this for the next 3 or 4 years. And so now, husband, you need to to help. You need to pay. So, and like you said, the fault in the breakup of the marriage, right? If you're getting a divorce because the spouse had an affair or because the spouse was abusive, like all of that stuff, the judge also looks at. So we had a case where we represented the husband, and the wife had made an allegation. She was requesting spousal support because they had been married for like 25 plus years, and they made a lot of money. And basically they had a conversation like 2 months before the affair happened. And for whatever reason, the client had recorded the conversation. And basically in the conversation, the wife was saying like, I want a divorce. And the husband was like, I agree. I'm done with this. Like, we're not good together. And then 2 months later, they were still living together, and they were still, I guess technically married. But 2 months later, the husband had an affair and got caught doing so. And in that particular case, the judge said that he wasn't going to make a false grounds divorce or grant it based on fault, because in his mind, the marriage was ended, 2 months prior, based on that recording. And so that was very helpful, because we were obviously concerned that our guy was going to have to pay, and there was going to be big issues with that. So it turned out well. So, Kamos, I think we beat that subject to death.
Absolutely.
Yeah?
Yes.
Okay.
So maybe he can pay the rent with spousal support. Let's tie that all back in.
So pay the lease when you get your spousal support. You're a jerk. Okay, I got you. My turn to read, or yours?
I don't even know.
I think it's my turn. It's my turn. Okay. I went to a judgment hearing after the divorce trial was concluded. After that, I see on the calendar that there's an order to show cause. I went to a judgment hearing after my divorce trial was concluded. After that, I see on the calendar that there was an order to show cause. Oh, entry of judgment scheduled on the court calendar for my divorce case almost 3 months after this judgment hearing. What does this mean? Do I need to attend this hearing?
What in the hell is a judgment hearing?
Floyd, you don't get what they're trying to say here. Like they went for a prove up, is what I presume, or a final hearing.
No, they had the final trial, then a judgment hearing, and now entry of judgment.
So the judgment hearing, maybe the court rendered at the judgment hearing.
Okay.
All
right. So we had a trial. The rendition was delayed. They came back. They got the order. Now you're set for entry. Now I follow. Okay. So what does this mean?
Wait, should we maybe explain to people that we don't read these questions clearly before we start answering them? Clearly.
Yeah, so we freestyle this.
There you go.
It is straight off the cuff.
Go.
I can speak for myself. I know how to read just fine.
Right.
Sometimes when Christina's reading it, it's the way it's written, and sometimes it's her ability to read. So yeah, sometimes the questions are written in a very confusing manner, and we have to try to decipher it as we're reading. So
yes, which I think we've done. So go read. Yeah. I mean, answer. You got it. All right. So final trial. So we'll start here. So sometimes in divorce cases or custody cases, the judge will not be ready to make a decision when you conclude the evidence, right? And so he'll ask for additional time to make his ruling. Sometimes he'll send out a letter saying this is what my ruling is, and sometimes he'll make you come back, which is what happened in this case, make you come back and tell you what his decision is. Okay. So after you get the ruling, then you have to get the order entered, right? In this case, it's going to be a final decree of divorce. And so after you get the ruling, what happens is generally the petitioner will draft the final decree of divorce. That will be sent to the attorney for the respondent. The attorney for the respondent will review it, make sure that it
complies with what the judge ordered. And if it doesn't, they'll send it back saying, make these changes, whatever, or additions, or whatever it is the problem is. And they go back and forth with it until they get an order that they both agree on. And then they sign it. If they can't agree on an order, then they go to the entry of judgment hearing. At that hearing, what's going to happen is they're going to have a copy of the transcript. And they're going to tell the judge basically what it is that what the disputes are over the order. You know, one party may say, I think it should say this, and the other says, I think it should say this. And judge is going to say, this is what it's going to say. And then you make those changes, and then the judge will sign it at that point. Most of the time, they'll sign it on that day. They'll make you either handwrite the changes in or whatever, go retype them and print it. Most courts will not let you leave an entry docket without signing an order.
Yeah. Yeah. So her question was, does she need to be there?
Her first question was, what does this mean? So I explained that fully. Now for the second part of your question, do you need to be there? Generally, no. Generally, we don't have our clients attend entry hearings because it's just legal arguments. I don't know of a court that requires parties attendance on entry. Do you?
No.
But if your attorney tells you to be there, you need to be there. So you need to follow your attorney's advice. But
Right.
Generally speaking, we don't have our clients appear at entries.
And I mean, I have had clients show up and they have this idea that if the judge sees them, then maybe the judge will know that they really care. Sometimes they just want to be there so that they know what happened. And I guess to make sure that I'm doing my job. And so you can be there. There's some instances that you can't. It's just, you may have a better use of your time someplace else. So
Generally speaking, you don't need to attend, which
Right.
was the question. Yeah.
It's been a really good past month. You know that?
I am fully aware.
Good.
Should I be the next question?
Yes, but I just want to add that people get super freaking frustrated with the entry of an order. And I cannot tell you the number of times where, because it's the last thing that you have to do on your case, right? And so, and typically by that point, people are exhausted. People are financially exhausted, and they're just like, I don't care. Like, why does this matter? And I will tell you that order, that final order, and making sure that everything is 100% accurate is probably the second most important thing. I think the first is probably the presentation of evidence, right? But the second most important thing in your entire case. Because if, let's just say hypothetically speaking, you go through this entire process and you have this contested trial, and in the oral rendition, when the judge announces it in court, the judge says, okay, mom, you're going to have primary conservatorship, and dad, you're going to have a standard possession with extended elections. And when that order is drafted, it does not give mom primary conservatorship, and maybe it gives dad some sort of restricted access. Right. And then let's say you guys don't worry about the order because you're exhausted and you're burnt out and you haven't looked at it. And 6 months later, all of a sudden there's an issue with where the kids are going to go to school and what holidays dad's supposed to have. And you go to your order and it's completely wrong. Well, at that particular point, you're screwed. And now you're going to have to start a new case to get all of that crap fixed. And so make sure that you're letting your attorney do their job. Make sure that they get the freaking order entered correctly, because you're going to need it. You're going to need it for the foreseeable future, and you want it to be done correctly. So,
and generally these things are 30 pages long. And if you've got the other attorney drafting it, right, we have to go through word by word, read it thoroughly to make sure nothing's been slipped in, or because there are some attorneys that put in a standard possession order and then we'll modify some small language in there that if you just breeze over it, you're going to miss it. And then you'll be mad at us for missing it. So we have to go through it with a fine-tooth comb to make sure it's correct.
Right. Right. So, and also, and I think I said this like, I don't know, a couple weeks ago, if you're a client, make sure that whatever attorney you've hired, that you are reviewing that order with your attorney, right? And if you're an attorney, make sure that you take the time to sit down and explain that order to your client, because I cannot tell you the number of times that I've had somebody come in and hire me on an enforcement, and they were like, oh, well, I didn't know that I was supposed to update my address and phone number to the state case registry and to the district clerk's office. And I immediately asked him, did your previous attorney not go over your order with you? Well, no, they didn't. They didn't say anything to me. I got it in my email and that was it. Don't do that. I mean, and if you hire an attorney that does that to you, then you need to sit down and you need to go through that order and maybe consult with a different attorney so they can explain it to you, because you can go to jail. Even if you don't understand it, you can go to jail. Cool tools. Can you tell I'm like really bothered by this? I'm very bothered by this whole thing.
You are. Yeah, you're just very bothered by everything today.
Well, I've been around you for half the day, so there you go.
I'll take that as a compliment. So, how do I protect my retirement income before divorce? I have started the application for my retirement to begin in September and had this planned for a year. She received an inheritance and moves out unexpectedly. I have no interest in her inheritance. That's good. Just want to be proactive if she wants a divorce.
Okay. So how do I protect my retirement income before divorce? I would say don't have a retirement account. There's nothing to protect. Because whatever you put into that account, it's going to be subject potentially to division, right? The Texas is a community property state. Any assets that are owned at time of divorce will be subject to division. And so, I mean, you could do some sort of partition and exchange agreement, although it does seem like divorce is going to happen pretty quickly. And so I don't know that either one of you would want to do a partition and exchange agreement. A partition exchange agreement is basically an agreement where you all agree that that community property is, if it's created, that it will, how does it work, Floyd?
So partition exchange modifies the character. So if it's community property, you agree to modify it to where it's, husband's separate property.
Right. But I'm trying to think of it like, I don't remember how it works though. So if it's just whoever purchases it, that's going to be awarded as their separate property? Or like, how does it work?
Well, so you're talking about a premarital agreement.
No, I'm talking about a partition and exchange.
So a partition exchange takes a specific piece of property and changes its character.
Okay.
The premarital agreement is the one that says anything that I acquire that would otherwise be community is now separate.
Well, and so like in this particular case, though, he could do a partition exchange and say, okay, yes, my retirement account is community, but we are going to agree that it will be my separate.
Yes.
Okay. So you could do that, assuming that you all were going to continue this marriage for the foreseeable future, right? If you are going to get a divorce, which it kind of seems like that may be happening sooner rather than later, then just don't contribute to your 401k until after your divorce, or maybe get divorced before September, if at all possible. I guess no, probably not, because it's August. So
September is just the disbursement date, right?
I think that's whenever they're going to start garnishing it from his check. So even at that, I mean, we're not going to be talking about a whole bunch of money. So yeah, I'd say just hold off.
What do you think about them doing a partition exchange on that inheritance money?
I think that wife would never do that.
Why?
Well, because that would be that's her separate property. And so why would she want to make that community? That doesn't make any sense. So no.
I don't think this guy knew that it was her separate property because he is giving it up.
Oh, right. Yeah. So any money that your spouse inherits, any money that is gifted to them, you don't have any rights to that, right? And so you're not giving anything up. She's keeping what's rightfully hers. So it's nice that you don't want it, but you would never get it. So yeah, that's for nothing. So, all right, what else? So one more question.
I think so.
Okay.
You should take some rabbit trails.
Is it my turn to read?
It is.
Several months ago, I added my wife to the deed, but I do have a question. Is there any way that I can reverse that or take her off? Is there any way that I can reverse that or maybe take her name off the deed if we decide to divorce?
Yeah, there is actually. You can do it if she signs a deed deeding you her interest. But no, generally you can't do it on your own if she's not going to agree. Unfortunately, what you now have done is gifted her half of the home. So it's still not community property. I presume he owned this house before. That's the presumption I'm going on. So still not community property. It's just that now instead of you having 100% interest in the home, you have 50%, and she also has 50%. Only way you could do it is if she voluntarily agrees to give you her interest in the home and deeds it back to you. Good luck with that. Yeah.
Please don't change property records without consulting an attorney and kind of figuring out like, what does this mean and what's going to happen? Because I can't tell you the number of times that people have done something like this. And of course they're thinking, well, I love my wife and I want to, and that's lovely. That's great. But make an informed decision, right? Understand that when you do that, you're not going to be able just to say, JK, I'm reversing this and let's go back to what it used to be, because you've potentially just wasted thousands and thousands of dollars. That sucks.
Yeah, but we see that quite a bit, actually.
Yeah. I'm trying to think. You said that it was automatically her separate property because you gifted it to her. I thought that there was something about the intent of it being a gift or something like that. No?
So yeah, if it's determined that it was in fact a gift, then it's her separate property.
Okay,
right?
But what if it was done to like refinance or something like that?
Then it would still be his separate property because he didn't intend a gift.
But what if for whatever reason, like they had to put her on the deed so that they could qualify for another loan to buy their vacation home or something?
Yeah, so that happens too. And it just depends. They look at all the factors, right, to determine whether it would qualify as a gift. And the first element of it being a gift is you have the intent to make a gift, right? And then there has to be a physical transfer, which there is with the deed, right? There's a transfer. But to argue whether or not he had the intent to make it a gift would look at factors like, did they make him do this to get a mortgage, right? So that's kind of
and if you're like a family member, because we've seen this too, where our client's married to his wife and then his mom and dad decide that they're going to gift him or deed him a home, that you have to have very specific language in that deed to make sure that when we, Lord forbid, in the future have to go in and represent you on a divorce, that we can prove up that that was in fact a gift to you as the husband to your sole and separate property estate, and not to potentially the community, because that's always what the wife says, right? Is no, his parents loved us and gave that house to us. And then you potentially have problems there. So just talk to lawyers before you make major life decisions.
always a good call.
Yes. So, all right. With that being said, thank you all for joining us. We hope that this information is helpful. We say this beginning, middle, and end of every single one of our events, and that
we didn't say it in the middle.
you said something about consulting with an attorney of your choosing or something like that. You did. So beginning and end, at least, do not accept this as legal advice. Okay. So, you can tell as we're going through these fact patterns, one little factor can change our entire opinion of a case. And so please, please, please hire a lawyer, hopefully somebody that is local to where you live, and represents clients in that particular county, and follow their advice. All right.
I know.
Okay, cool tools. Have a happy Friday.
Toodles.